Okay, good day, gentlemen. Ladies and gentlemen, we are going to continue with our course, Law on Partnership and Contracts. So this is now part 3 of partnership, and the topic that we're going to take is dissolution of partnership. Partnerships will undergo dissolution. This is the cessation of the business partners relationship. So we define dissolution as a change in the relationship of the partners. This is caused by any partner ceasing to be associated in the carrying on of the business. So partnership is not terminated at this stage, but continues until the winding up of partnership affairs is completed. So what is winding up? This is the stage where the partnership undergoes the process of settling the business or partnership affairs after dissolution. So in this process, the inventory of the business or the assets of the business are sold or liquidated, and the liabilities of the partnership are paid or settled. No? Then we have termination. Termination is the point when all partnership affairs, meaning all the debts, the obligations, and all the assets are completely wound up and finally settled. So this signifies the end of the partnership life. So there are several causes of dissolution. Number one is there is no violation of the agreement among the partners. Nobody has violated the terms and conditions of the partnership. So this happens when, letter A, by termination of the definite term, or by completion of a particular undertaking, which is specified in the agreement. So if the life of the partnership is good for 3 years or 5 years, so in the end of 3 years or 5 years, then the partnership is dissolved because the definite term has arrived. Or if a particular undertaking has been completed, let's say the partnership is handling the construction of the third bridge. So once the third bridge of Cebu to Mactan has been completed, then the partnership is dissolved. Letter B, by the express will of the partner or any partner who acts in good faith, and there is no definite term or particular undertaking specified. So this time there is no term, there is no undertaking, but the cause is by the express will of any partner. So if any partner will decide to leave the partnership in good faith, then the partnership will be dissolved. Let us see by the express will of all the partners who have not assigned their interest, assigned is transfer, so or charged them for their separate debts, either before or after the termination of any specific term or particular undertaking. So this time, let us see, it involves the express will of all the partners. So letter B is the will of any partner, but this time all the partners have agreed to terminate the partnership. And these partners have not assigned any of their interest. So nobody has transferred their interest to another person. Letter D is by the bona fide expulsion of any partner from the business in accordance with the power conferred by the agreement. So if one partner has been expelled, then the partnership has to be dissolved. No? So there are different modes of expelling a partner, right? So when a partner, let's say for instance, an industrial partner undertakes to have a business or another business on his own without the consent of the other partners, then he is expelled. Then at this point, the partnership would be dissolved by the expulsion of the industrial partner. Okay, let's go to number 2. This is in contravention of the agreement between the partners. So there's a breach or contravention of the terms of the partners' agreement. So where the circumstances do not permit a dissolution under any other provision of this article but the express will of any partner at any time. So there is already a contravention, there is a violation of the agreement committed by one of the partners, or maybe most of the partners, or if not all of the partners, then by the express will of any partner at any time, the partnership will be dissolved. Number 3, by the event or by any event which makes it unlawful for the business to be carried on, for the business to carry it on the partnership. So the partnership business has become unlawful, okay, illegal. So probably there's a law making its product illegal. Like for instance, I already made an example. If the produce or the product being produced by the partnership is firecrackers or fireworks, and then there comes this new law banning the sale of fireworks or firecrackers, then the business becomes illegal. So that example falls under number 3. Number 4, by the loss of specific thing which is promised by a partner and before its delivery. So this is the partner's contribution that he promised to deliver but failed to do so. Then the thing he promised was lost. No? So partnership will have to be dissolved because one of the partners failed to deliver his contribution to the partnership. So number 5, when any of the partners dies or death of any partner, partnership is dissolved. Number 6, when insolvency of the partner or when the partnership is pronounced or declared by court as insolvent. Again, insolvent is that it's not declared by the person but declared by a competent court. So it should be the court to declare the person as insolvent or the partnership as insolvent. So one can become insolvent when it fails to pay its debts when they become mature, and but still the partnership or the person still has assets, but it's not enough to pay once the liabilities or his debts fall due. Number 7 is civil interdiction of any partner. Again, civil interdiction happens when a person is found guilty of committing a crime and that crime carries a penalty of imprisonment of more than 6 years. And number 8, by decree of court under Article 1831. So what are these instances? Number 8. So these are the following. Number 1, when a partner is declared insane, nabuang, in a judicial proceeding or shown to be of unsound mind. So it's the court, that declared the person as insane. Number 2, incapacity of partner is also declared in a court. So this one needs the filing of the case in court, because it needs a decree or ruling of the court. So incapacity could be of due to physical or mental or emotional incapacity of the partner. So emotional could be a nervous breakdown. Diba? If one is undergoing nervous breakdown, he cannot fully decide a business decision or a business matter. If one is already demented, naango-ango na, kalimtano na kayo, then he is already incapacitated to perform as a partner. And one if is what else? If one becomes physically incapable, like he's sick, sakit na, sick of heart attack, or is at ICU, suffering from illness, lingering illness. So this happens. When this happens, then any partner can file the dissolution of the partnership before a court of law. And number 3, when a partner is guilty of conduct prejudicial to business of the partnership. So this happens when a partner is guilty of fraud or committing or taking cash or assets of the partnership without consent or knowledge of the other partners. Number 4, willful or persistent breach of partnership agreement. So breach is the violation of the terms of the agreement. So if the partnership agreement has been violated, then this can be a ground for dissolution, but it must be filed before a court. Or conduct which makes it reasonably impracticable to carry on partnership with him. So a partner lost his trust and confidence on the partner. Number 5, business can only be carried on at a loss. So this time the business of the partnership is not good anymore, probably affected by the COVID-19, so virus. So partners decide to dissolve the partnership, but it must be dissolved. It must be filed before a court. Number 6, other circumstances which render dissolution equitable. So equitable is fair, meaning it is only fair to dissolve the partnership. Now, if a partner has transferred his interest to another person, so that person has also a right for dissolution of the partnership. And these are the following instances when a transferee or an assignee or a purchaser of partner's interest can apply after termination of specified term or particular undertaking. So this time there's a specific term like 3 years or 5 years, but then the partner still continues the business of the partnership. Then if there's a purchaser or a transferee of the partner's interest, then he may apply before a court of law for the dissolution of the partnership. Or the particular undertaking has been completed, but still the partners continue the business of the partnership. But there is a purchaser of a partner's interest. So this purchaser, he can go to court and apply for the termination of or the dissolution of the partnership. Number 2, a purchaser of partner's interest may file for dissolution or apply for dissolution if at any time the partnership at will, when interest was assigned or charging order issued. So there is assignment of interest again to another person, or there is a charging order issued by a court of law. So probably the court has decided that a partner's interest should be transferred to the creditor. And ay utang ang partner then is foreclosed. So what are the effects of dissolution? So the general rule of dissolution, it affects the authority of the partners to bind the partnership. So he can no longer bind the partnership. So any partner for that matter, dili na sila pwede mag-transact, no? They are prohibited to bind the partnership. But there are exceptions. So it should be S here, sections 1 and 2. So the first exception is that the partners can still bind the partnership or enter into a contract with a third person or another person who is not a partner. Number one, when that contract is to wind up partnership affairs. So what are these affairs? Selling of assets. So they can sell assets. That's number one. Number two, they can that's selling of assets or selling of the rights of the partnership. And number two, complete transactions which are not yet finished. So if there are pending transactions, like for instance, the erection of the building or the bridge is still not yet completed, and then this time the partnership is engaged in constructing the third bridge of Cebu to Mactan, no? But then the partners decide to dissolve the partnership. So this time the partners can transact whatever businesses in order to complete the construction of the third bridge. So that's number two, complete the transactions which are not yet finished. So there are qualifications in order to fall under this authority. So number one, with respect to partners, the dissolution with respect to partners. So what are the effects, no? So letter A, the authority of partners to bind partnership may by new contract is immediately terminated. So when dissolution is not due to act, due to death or insolvency of any partner. So act, death, or insolvency is Atty. So if it is not due to act, death, or insolvency, then the contract or the authority of the partners to bind a partnership to a new contract is immediately terminated. No? So a partner can only bind a partnership by a new contract if the dissolution is due to Atty. Okay. Now, if due to Atty, the partners are liable as if the partnership is not dissolved. When the following situations occur. Number one, if cause is act of partner, an acting partner must have knowledge of such dissolution. So even though if it's Atty, but the acting partner has knowledge that the partnership has already been dissolved, no? So the partners now are liable for any transactions that they transact, no? Not the partnership, but the partners. Number two, if cause is death or insolvency, meaning cause of the dissolution is death or insolvency of any partner, and the acting partner has knowledge or notice of such death or insolvency, but still decided to bind the partnership to a new contract. Okay, so letter A here, this one, they're only allowed to bind the partnership by new contract if they have the partner who is acting or binding the partnership has no knowledge of has no knowledge of the death or insolvency of another partner. So zero knowledge. But if there is knowledge, then only the partners are liable, not the partnership. No? Meaning the partners who transacted the completed the transaction. Now, the dissolution with respect to persons, not partners. So partner who continues to bind the partnership even after dissolution in the following case. So we already discussed this. Number one, transactions in connection of to wind up the partnership and to complete transactions unfinished or pending. So discussed that already. Now, if the partner cannot, this letter B is when a partner cannot bind the partnership anymore after dissolution. So number one, where dissolution is due to unlawfulness to carry on with business. No? So it has been declared that the partnership is product is illegal. So instantly a partner cannot bind the partnership anymore. Illegal na good, no? Number two, where the partner has become insolvent. So partner cannot bind. If he is declared insolvent, so he cannot bind the partnership anymore. So who declares a person insolvent? It's the court. No? If a court declares you as insolvent, you are no longer capable of giving consent. So therefore, you cannot bind the partnership anymore, much as to yourself, no? Because you are already incapacitated. Number three, where partner unauthorized to wind up partnership affairs, except by transaction with one who, number one, had extended credit to partnership prior to dissolution. So there is already extended credit to partnership before the dissolution happened. Number two, had no knowledge or notice of dissolution. So in this case, the person or the partner who is unauthorized to wind up the affairs has no knowledge that the partnership is undergoing dissolution. So, wala siya kalibutan ani. Letter B, situation number two. If the partners unauthorized to wind up the partnership did not extend credit to partnership prior to dissolution and had known partnership prior to dissolution and had no knowledge, notice of dissolution, fact of dissolution, not advertised in newspaper or general circulation, the place where partnership is regularly carried. No? So all these three must be present in situation two, and all these two must be present in situation number one. Because when a partnership undergoes dissolution, there are persons or partners who are authorized to wind up the partnership. Now in this case, these people or this partner is not selected to wind up or not authorized to wind up. So these are the situations where he can still bind the partnership. No? First, he has no knowledge. Second, he has extended credit to the partnership before the dissolution. Another, there is no extended partnership, but had known partnership prior to dissolution. So there's already knowledge. And there's no knowledge. There's already here. What I mean is there is already a relationship between the partnership and the other person or the third person they are transacting. No? Had known partnership prior to dissolution. It's number two. Then no knowledge of or notice of the fact of that the partnership is in the process of dissolution. Now, dissolution should be advertised in a newspaper. Okay.